Hello, this is Matt on the Moon Lambeau channel, and here's the headline from you today. Judge delivers blow to Ripple over foreign discovery. And so, look, I'll say this. It seems to me like this would be more of a serious blow for Ripple in terms of how it might impact the relationship that they have with existing clients, because, as I'll explain in this video, it's impacting them, unquestionably. Now, as far as how it's going to impact the case, based on what I've seen from the attorneys that I follow, not as big a deal. And in fact, it's just to keep a little positive here, this is in line with reality, though. So Ripple's been winning, like, frankly, I mean, obviously this is pre-trial stuff, but in terms of the motions that have been filed, Ripple's won all of them until this point. And in fact, the most important motion, and this is just my humble opinion on this, but the most important one had to do with whether or not information that the SEC held having to do with how they determined whether or not Bitcoin and Ethereum were securities, like, that is discoverable. And the SEC was trying to keep that information private. They don't want that to be known by Ripple. They don't want it to be discussed in the trial because it weakens their case probably substantially. I mean, if there's a skeleton in the closet in terms of the rationale or thought process between, like, imagine just between the determining if like how Ethereum is not a security but then XRP is, well, if in terms of the thought process they went through, if there's substantial overlap, that's going to look really bad for the SEC. So the fact that Ripple had won that one in the past, I think that's of substantially more importance than this. But still, this is bad for Ripple in particular because it's putting strain on their customer relationships, and I think that's verifiably true as well. But before I go any further, I do want to be clear, I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who makes YouTube videos as a super duper fun hobby about Ripple and XRP and crypto, but that is all that's going on here. And so just as a quick refresher, because I want to make sure we have the table properly set so that you know what we're talking about, I just want to spend just a minute or two going back just to explain what is actually being discussed and what was ultimately ruled on here. And so here's an article from April 19th. This is over a month ago now, from Forecast News, titled, Ripple accuses SEC of intimidation tactic in seeking XRP info overseas. And, oh, by the way, I'll let you know now too, I do have fresh takes on this from two attorneys from the XRP community. So it's good to get opinion from somebody that's outside the SEC and outside of Ripple. But take a look at this. So, heating up their battle over discovery, Ripple Labs, its CEO Brad Garlinghouse, and Executive Chairman Chris Larsen are asking a judge to stop the U.S. Securities and Exchange Commission from asking foreign regulators to obtain information on Ripple and XRP on the SEC's behalf. According to a joint letter to U.S. Magistrate Judge Sarah Netburn filed on April 16th, the lawyers representing defendants Ripple, Garlinghouse, and Larsen said the SEC was pursuing discovery outside the scope of the federal rules of the Hague Convention and by improperly leveraging memoranda of understanding with foreign regulators who then, at the SEC's request, serve burdensome document requests on entities under the foreign regulator's jurisdiction. And so that's what's at the heart of this, the Memoranda of Understanding, or MOU for short. And so this is being perceived as a tremendous bullying tactic, as you'll see articulated rather succinctly on more than one occasion from multiple attorneys, actually. But anyway, piece continues. The MOU process involves a foreign securities regulator in the discovery process, which has a significant impact on the recipient of the requests, including Ripple's overseas business partners, ding, 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 and amounts to an unwarranted intimidation tactic, the lawyers wrote. And so, to be clear here, as stated in this article, MOUs are formal agreements between two or more parties. In this case, the U.S. and foreign regulators have MOUs to facilitate the sharing of information. Such MOUs typically allow the regulator in one country to make a request to another agency in the foreign jurisdiction to collect information on its behalf and share the information with the requesting agency. And so when this broke, I mean, there were opinions all over crypto media that were highlighted from, for instance, Jeremy Hogan. I think I had one lined up here. Yeah, and so this is from April, back when this news broke. Here's what Jeremy Hogan, XRP community member and attorney, had to say about this. This is a quote. "This is not something a typical plaintiff could do, and it's not fair, so Ripple is calling dirty poker. This is typical government prosecutorial pressure litigation, applying pressure not only to you, but your business friends as well." And then there's attorney Jesse Hines, another member of the XRP community, who wrote at the time, "Shame on the SEC. On the bright side, the SEC is basically admitting that this is a matter of great political and worldwide significance. Can't wait for that summary judgment motion with a major questions doctrine argument." And so, as far as what happened today, and by the way, I'm going to go through this brand new article which explains things, but also, do you hear that? Those are dead trees, my friends. I bought a printer for home. So I actually own a bunch of printers because I'm a business owner, but I haven't had a printer at home in, I don't know, like 15 years because I don't print a damn thing because it's 2021. But I got to admit, with all the legal stuff that's happening and prepping to make videos for YouTube, not having physical paper and relying on like a tablet or this or that and highlighting stuff on a tablet, much more annoying than just having physical paper, using an actual highlighter, and just notating for myself what I want to cover in videos that way. So you're hearing slaughtered trees as a result of all this. So it's not just Ripple and Brad Garlinghouse and Chris Larson that are having tough times. It's also the trees. The trees have seen better days here. I'm just slaughtering them like crazy. But check this out. But anyway, so I highlighted some spots. I'm gonna specifically share with you that I just found very interesting. But let me start with this. This is the brand new article now. This is the one that was titled "Judge Delivers Blow to Ripple Over Foreign Discovery." Magistrate Judge Sarah Netburn has denied Ripple's motion to stop the U.S. Securities and Exchange Commission from sending Memorandum of Understanding requests, that's the MOU for short, to foreign securities regulators. As reported by You Today, Ripple claimed that such requests were meant to intimidate its foreign business partners, but the judge asserts that there is no evidence to suggest that they were issued in bad faith. Now, the defendants wanted to compel the SEC to use the slow and inefficient Hague Convention process, but Netburn says that the MOU requests are permissible. And here's a quote. "There has been no argument that the requests exceed the scope of any governing bilateral agreement. Instead, courts have routinely rejected the proposition that the Hague Convention is the exclusive or priority means of conducting foreign discovery." So here's the initial sentence that I highlighted, just so you can get the actual the way that it was worded from Judge Sarah Netburn. The defendants move the court for an order directing the Securities and Exchange Commission to withdraw its foreign request for assistance, to stop further discovery through such requests, and to produce all previously served requests and any related communications with foreign regulators. The motion is denied. Womp womp. But we were kind of expecting that, as you will see. And so here's something that XRP community member and attorney James Filan shared as soon as this news broke. Breaking: decision on MOUs. SEC can continue to use MOU process, but the SEC is ordered to produce all documents obtained in response to the requests. In addition, to improve transparency in the process, the SEC is ordered to produce copies of all previously served requests within 14 days and produce any subsequent requests within 14 days of their service. To the extent the SEC believes it has a proper claim of privilege, it must simultaneously produce a privilege log. And so here's where some real opinion gets out. This is from attorney Jeremy Hogan, who thinks that this is a bunch of nonsense. And it was interesting, too, because frankly, the outcome we got here, which was not in favor of Ripple, that was what he was initially thinking was going to happen. It wasn't until very recently that he kind of flipped on that temporarily, and he thought, okay, now this is actually probably going to go in Ripple's favor. But the primary reason, is that the court was taking so long to actually respond to Ripple's the motion here with some sort of final decision on this. The fact that it was taking so long was making Jeremy Hogan think, okay, well, why the hell would it take this long? If not for the fact that, given that this is outside of precedent, perhaps we have to give a sufficiently long legal explanation of why we're doing what we're doing, but that wasn't the case. And so we are, in that sense, kind of left scratching our heads. But outside of that happening, he did think that this would not be a win for Ripple. And so here's what he wrote on this. This is Jeremy Hogan now. My initial impression after the hearing was correct. The judge rules in the SEC's favor on the MOU issue. I believe this is the wrong ruling and shows the judge does not understand what is truly going on with those requests. Also, why did this 2-page order take 3 weeks to draft? Now that's a legit question. I have no idea why this short thing is actually 3 pages, but I don't know why it would take that long to draft. And then he wrote, yes, there is a disclosure requirement, but the real reason the SEC uses the MOUs is to intimidate and ruin business relationships between defendants and the subjects of the requests. It's this bully tactic that we need judges to stop, and it irritates me greatly. I need a drink. Yeah, I hear you, man. And so that's why I was saying, like, this is a serious blow for Ripple as a company in terms of what it does to their business relationships, in terms of what it's going to do for the discovery process and ultimately the court case. I'm not necessarily, at least at this point, from what I've seen from the attorneys that have shared opinions, I'm not as convinced that that is going to be a big deal. It's just that it's an annoying, stupid bully tactic. And it does look like it. That's what the optics appear to be as far as I'm concerned. But let me quote something from Judge Sarah Netburn in this decision. She wrote the following. No evidence suggests that the SEC issued its requests in bad faith. Okay, but what the hell's the reason for doing it? I mean, I'll take her at her word actually on that. There isn't any actual evidence, but why are you doing what you're doing? Like this, I just don't see that. It's crazy here. And then also she wrote. Here's another part. I highlighted this as well. She wrote, these agreements permit the SEC to request information from foreign securities regulators who may decline the requests, which has happened in response to a few of the SEC's requests in this case. Yeah. And so, look, I remember that being brought up before. She said that her understanding was that these requests could be denied, and so it's not like the SEC is forcing this information out into the public, like not with absolute power or anything like that, because these things can be denied. But here's the thing: I don't know every entity that has been called upon to produce information, but yes, a lot of Ripple customers, we do know that, but there are other entities out there, I believe parts of various governments, and so I haven't seen anything to indicate that there have been any denials on behalf of Ripple customers, because again, it's not Ripple's customers overseas that can say no, we're not going to provide this information. They can't deny it. It would be their government that could say no, we're not going to require this information of the company here in our country. And so, to any entity that has been able to forego having to share this information, I'm just wondering if they're all in some sort of government level. I haven't seen any evidence that any sort of Ripple customer is able to say, no, we don't want to do this. And well, they can't. But again, I haven't seen any evidence that their government has shut the SEC down effectively. So we'll see. And then I also highlighted this portion from Judge Sarah Netburn, who wrote, the fact that this discovery tool is one-sided does not render it unlawful. Parties to litigation routinely experience imbalances in resources or otherwise. Indeed, Rule 1 makes clear that the rules are intended to ensure the just, speedy, and inexpensive determination of every action and proceeding. The SEC's MOU process allows the agency to quickly and inexpensively obtain information that might otherwise slow this case to a halt. I don't know. I don't know that it would necessarily. I mean, I'm sure there'll be all sorts of opinions from attorneys in the days to come. We can talk more about this in the future if there's some more interesting stuff to say about it. I certainly don't want the case to go any slower personally. I would, because honestly, given that the SEC has tied XRP to Ripple in such a way that it did tank, not because and that was not a representation or some sort of piece of evidence that XRP is a security of Ripple. It was evidence that the SEC said that XRP is a security of Ripple, and that's why it tanked, of course. And so if the sooner we can get this cleared up, just as an XRP holder, the better, because I still think that you're probably, if I had to guess for fun, and this is not financial advice, but I suspect that XRP's price is going to notably rally as soon as we get some sort of final clarity, whether that means full adjudication here or if we get some sort of settlement. Either way, I think it's going to be very good for XRP holders. I mean, you saw what happened, right? With the KIN token, when it got regulatory clarity, it rocketed up over some time period, up over 2,000%. And we're in a bull market. Look, I know what happened with the crypto price action over the last day, but damn it, guys, we're still in a bull market, okay? And so getting that clarity, it's not gonna hurt. And I still think XRP is gonna run either way, and I've been pretty clear about that on my channel. But the sooner you get clarity, the sooner you might get some fun price action. So we shall see here. But again, in the end, as far as what the impact this might have on the actual court case, I'm not convinced from anything I've seen from lawyers that this is going to be some sort of crushing defeat in that sense. And really, Ripple's just been handing it to the SEC. Like, my gosh, I would much rather be defending Ripple than defending the SEC's position. If I were a lawyer, and I'm not, but if I were, I would much rather be defending Ripple. They seem to be in a much better position than the SEC. Even so, still hoping that there's just going to be settlement instead of full adjudication. Just for me as an XRP holder, I just want this thing behind. The rest of the space, I think that they would appreciate more than that. They'd probably appreciate full adjudication, and beyond that, regulatory clarity. But even if there's a settlement, you can still provide, if you're the SEC, sufficient regulatory clarity for the space. So, don't do it at the expense of Ripple. That's a bunch of nonsense what they're doing here. And so there we go. Trying to get information that the SEC wants to be discoverable, and it's going to happen, unfortunately. But not the end of the world. All right, I'll go ahead and wrap up there. I'm not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.